Good afternoon, everybody. Keith here. Hoping everybody's having a good day, enjoying life, living life, loving life. Want to get on today and talk about the First Amendment audits. And what that's all about. And I haven't done any First Amendment audits myself yet. But if I ever do, or when I do, because I imagine, especially with weather getting nice here, I'm going to have to get a phone with some service so I can start doing something like that. Or get a camera that will automatically upload to the cloud. I don't know. I don't know about that stuff yet, but we'll be doing that eventually, I think. But in the meantime, I at least want to talk about it because that's one of the things that I do in my actions is I search things out first. So in doing my research, of course, watching all these First Amendment audits on YouTube and various different places, I've done my own research on case law and stuff. And of course, that's always relative to pretty much every other case there is in court because it always comes down to your First Amendment or the First Amendment and the principles that are underlying in that First Amendment. Now, the principles that are underlying in that First Amendment, we have to realize are actually placed somewhere else because the First Amendment itself gets its authority from somewhere else. We all know this. I mean, the Constitution didn't just write itself, okay? Somebody wrote it, and that's where it supposedly gets its authority. And again, that authority comes from the underlying principles. Now, the Constitution being written long, long time ago got its underlying principles somewhere else. So we see the underlying principle is not a matter of the statutory language that we use today, but rather is the statutory language that we use today is dependent on the previous language and the principles that previous language came from. So it's a matter of time and not the written words. So we have a principle as opposed to the written words. And so in the research and my possibility of being a First Amendment auditor in the future, in that research, I drew up a post, and I just posted it not too long ago, and I wanted to get on and do a video on it real quick, because I think it's that important. I think it's important in the aspect for every other case, like I said, because that's in fact what we're doing. See, in all cases, we're actually doing an audit. That's our job as people, is to audit the record that they pose in the public venue that they're using to supposedly regulate and legislate the people. Okay? So let's take a look at it. In the proper perspective of that principle. And like I said, that principle comes as a matter of time in other languages throughout time. And that's where we're at today in these First Amendment audits as they're opposed in the Congress and the First Amendment to the Constitution. Today's modern word. It actually comes from the Lord's Prayer. That Lord's Prayer is established in the Treaty of Berne in the Preamble in communications. They specifically talking about communications. And that's what we're doing in the Lord's Prayer. We're told to pray in this manner and then speak the Lord's Prayer. We're also supposed to do that in private, in the secrecy We're not supposed to be going out and touting our ego of praising the Lord in public. That's what the temples are for. We're supposed to gather together in temples and join together there, and not in their places of commerce. And that was the reason Jesus kicked the bankers and those that were selling doves even. It wasn't just the tax collectors and bankers that he kicked out of the temple. He collected anybody doing commerce in the temple. And they did it in the temple because that's where people generally gathered. They didn't want to gather at the tax collecting booth. They didn't want to gather at the Roman fortress. They didn't want to gather at lunch with the Roman soldiers. They wanted to gather with each other of the like kind. And so, in order for the commercial environment to institute itself in that time, it had to go to the temples, and this is why Jesus kicked them out of the temples. That Treaty of Berne in the Preamble talks about that communication, and that communication is a privity. So when we talk about the private aspects of our lives, we're supposed to do that in private. We're not supposed to do that in public. That's the separation of public and private. Now, if we do that out in a public venue, such as a temple or a park, then we're allowed to do that because there's nothing that says we can't. And this is the point that I want to make today. In all of their codes and everything, all of those codes pertain to certain aspects of personage. And that is the bankers and the commerce, the people trying to sell their doves. That's their language. It's called legalese. And we have a right to write things in privacy. And in that right of privacy, we have the right to even disassociate with their language. So, let's get on with it. First, I want to point out, again, like I said, we have a right in that those codes and everything. They don't have anything that says we can't use our own language, folks. There's nothing in those codes that says we can't use our own language. In fact, it even has in their code that if there is a foreign language, then you need to bring in an interpreter. Okay? So if I bring in my own language, and there is no one else who can interpret it but me. I am the original source. There is no other source. Okay? This is going back to the principle of they don't have any law that says I can't do something, then I can. So let's take a look at it in regards to the post. I got to downsize my screen again. There we go. Oops. And before I get into it, I want to continue on with this list I've got in front of me to show you connections. As I spoke, the Lord's Prayer is where everything comes from, the biblical scriptures. Everything has to be done under peace, but they institute a law of war for enforcement in case somebody breaches the peace. Okay? And that's in fact what we're talking about, breaches of peace. Not breaking the law of war, which then commences penal actions, but breaching the peace first by entering in to that war. You have already breached the peace. That is a given. So until you go back to peace, you are involved in that war. Okay? So as I mentioned, it extends from the Lord's Prayer, goes to the Treaty of Berne in the Preamble, which is the communication. And then it goes to the Constitution of the UPU, like I said, with the law of nations enforcing it through a military, but it's indentured through the Constitution of the Universal Postal Union, Article 1. Freedom of transit is guaranteed throughout the entire territory of the Union. That freedom of transit isn't just the freedom of transit as you would think in a physical sense of being able to move yourself from point A to point B, but also in communications of data elements, moving them from point A to point B. That is a transit. So we are talking about physical form as well as the intellectual and intangible forms of transit. That goes to the first prayer of Congress. Okay, the first prayer comes before the First Amendment. And then we have the Preamble of the Constitution that says to form a more perfect union. Okay, again, that to form a more perfect union is the intangible and physical, tangible communications that we involve each other with in everyday incidents, whether they be public or private. Then we talk about that First Amendment, freedom of the press and all that, and the freedom. The Congress shall make no law establishing the respecting the establishment of religion. So they can't make any religious laws. They can't make any spiritual laws. So that's what tells us that once we become subject ourselves to the Constitution or any of their statutory codes, we have entered into that law of war, and we ourselves have breached the peace. So we go to U.S. Constitution, Article 1, Section 8, Clause 8. And that is the one that reverts right back to the Treaty of Berne, protecting your original works. And that original work is, again, if you wish to take upon the Lord's Prayer, as opposed to entering into their law of war by using their codes and forms. So you either stick with the form of the Lord's Prayer, praying in this manner in private, or you subject yourself to the petitioning of a fictional entity in the form of law known as Battle of the Forms. Okay? So let's get on with this recording in public. And I'll drop those in the header when I get done and post this video and everything. I'll put the Lord's Prayer, the Treaty of Berne, Constitution of UPU, Article 1, First Prayer of Congress, Preamble of U.S. Constitution, the U.S. Constitution, Article 1, Section 8, Clause 8. I will post those. Those are the order of things. And then once you get to the U.S. Constitution, Article 1, Section 8, Clause 8, that refers to Article 1, Section 1, which is the Congress is laying and collecting taxes, duties, and imposts. Things that are posted to a record. Impost. Now, the thing is that their public record is perpetuated through their public forums, whether it be a library, a restaurant, a motel, hotel, a convention center, a public official, a public agency, a public program. Those are all public records, educational records, informational records, experimental records, medical records, legal records, documentational records, whereas your record is a private record. Again, that privity. Okay? All of that other stuff, that's all legalese. You have a right to what's known as journalese. You have a right to journal in your own form, your own language. So, recording in public, I hope to bring a different approach to the right of right to document interactions in public. See, that Treaty of Berne protects your right to document. Okay? Now, whether you use a camera or a phone or something like that to document it makes no difference. That is just a device to document. You could write it down, but because of modern technology and modern convenience and the equality of the law among the states and its reference to equality among the people to use the same instrumentalities for their own protections of those same very rights in the same manner, It's just like going into court and being able to take a phone into court. They profess, well, we're recording it. Well, that doesn't dismiss the concept that I have a right to record for my own reviewing purposes later on. See, if I want a recording from the court, I have to submit a petition to the court to get that recording, correct? Yes. Well, then I have the right to record for my own permissions without the state's permissions. Because I have permissions, and the state records that in their own 9th Amendment of the Constitution of the United States, wherein the rights enumerated within are not a full-scale listing of the rights that may be. Okay? So that's the other approach. Just because you have permissions doesn't mean I have further permission, or don't have further permissions. And your permissions even recognize those external permissions. Public Law 97-280 recognizes the King James Version of the Bible, 1611 print, as the law of the land. And I'd like everybody to note that that particular version, 1611 version of the King James Version of the Bible, is not, I repeat, is not copywritten. It is, in fact, a perpetual copyright issued by the England's Queen to keep it perpetual. In other words, it is being operated under the Treaty of Berne as an original work by presumption because it was written before the statutes, codes, ordinances, and such like that. And therefore, it needs somebody to step up and protect it because its original authors are no longer around, and such as today's copyright concept was not evolved. As it has evolved today, if it weren't protected by somebody, it would have been by the bands, by the wayside through the book burnings. That book burning would have been successful. Okay? So somebody has to step up and protect it. That's an operation of law. It is not an infringement. And it is not an actual literal copyright for commercial purposes, but rather for perpetual reasons to keep it around so it can be an educational tool, just like the Constitution, which itself does not have that same perpetuity. Okay? Filming and recording in public is becoming an ever more popular activity for private journalists, private journalists, activists, and people around the world. For good reason. Instances of police misconduct and outright seditious behavior, and I should have put treasonous and seditious behavior, of various public servants captured by way of recording events with electronic devices have brought this topic to a greater light since the George Floyd incident. And it's actually been growing since before that, but since the George Floyd incident, these First Amendment audits have really amped up. It's like when people found out that trading cards, baseball trading cards were a thing, and all of a sudden everybody got into it and flooded the market, and now it became useless. Okay? The same thing is happening with the First Amendment audits. All these First Amendment audits are popping up, and they're capturing a lot of data elements, but they're not having a whole lot of success because of their approach. Their approach is fundamentally founded in the constitutional rights. When I assert that we need to find a different approach, we need to bring it from an outside light. I hope to bring that today. Now, litigation surrounding alleged violations of rights to record during these types of encounters are working their way through the legal system. To date, the United States Supreme Court has not yet weighed in on this specific issue. Do not get it wrong. All this case law that these First Amendment auditors are bringing are based on opinions. The courts have issued nothing but opinions that have never actually been settled. They've never settled anything in regards to a right to do something. And I will focus on this later as the remedy. The actual argument put forward for citizens' right to record law enforcement in the routine performance of their duties has been under the First Amendment to the U.S. Constitution by the expression of authority, which is Congress. Everything's been done under that, like I said. Article 1, Section 8, Clause 1. Congress shall lay and collect taxes, duties, and imposts. And that is a post. They posted it in the Constitution. Yeah, that's their post. The First Amendment states, Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof, or abridging the freedom of speech or of the press, or the right of the people peaceably to assemble and to petition the government for redress of grievance, or the right of people peaceably to assemble, going out in their streets under the Militia Act, acting like a dick with a sidearm on your side, is not a peaceable assembly. Is showing that you are willing to go to war. You are a warring faction. You are enforcing the Second Amendment. Without delving into the intricacies of First Amendment protections, the majority of the federal circuits in the United States presented with this issue have concluded that the First Amendment protects a range of conduct, a range of rights, and not specifically your right to record, surrounding the gathering and dissemination of information, which is not just your right to record, but the right to publish it, the right to conform it to your intended use. So if you wanted to record the police and make something of a comedy skit, you would have to let them know that is what you're gathering the information for. That is what your right is. Your right in gathering the information to make a comedy skit, just like Saturday Night Live. Or possibly your right to gather the information and disseminate it for your protection by gathering that information and making a claim. Or gathering the information and dissemination of information to prove an unlawful claim. Say I wanted to go up and do a First Amendment audit and I found a police officer parked his car on a handicapped parking spot. And he come out and approached me and asked me what I was doing. I would have to tell him in my own conscience, in my own intent and of right and righteousness, let him know that I was recording unlawful activity being committed by him, and I was gathering that information so I could disseminate it to his superiors and my superiors. Does that make sense? I'm not just here protecting my First Amendment right to film. I'm expanding upon that and letting him know I am gathering information of an unlawful activity being committed by him, and my intent is to disseminate it to his superiors and mine. I do not need to have a conversation with him. This is not court on the side of the road. I got the information I need, and I will make my report to his superiors. I will do that in private. I am not here to make a public incident. Okay? This is how I will operate if I do First Amendment audits. I'm not going to sit there and argue with I have a right to First Amendment. That is not what I'm doing. I'm not supporting a First Amendment constitutional right. I am here to gather and disseminate information of unlawful activities. Period. It has nothing to do with my right to First Amendment right to film police in public. Everybody has that right under the Constitution. But my approach is superior to the Constitution because the Constitution is providing rights for that officer, and I'm gathering and disseminating information that that officer is violating the oath that he took to that Constitution. Okay? Including the right of individuals to videotape police officers performing their duties in public. See, I'm not going to go into your private domain. I'm not going to go up to your private house and start recording you or anything like that. If I'm out in the public and I'm recording things in public, that is my purpose, is to record and disseminate public violations, as well as to record and disseminate things in public that I find very, very artistic, talented, humane, gracious. My public record is not going to be of nothing but criminal activities. As you see today, the last six years of my public record has not been recording public servants violating the public law. Mine has been exposing the public domain and how I perceive it, my opinions on it. And I have a right to do that. And that's what I've been doing. That's why they cannot take my content down. That is why you don't see the same thing on other people's pages where content not available. Because I'm not posting bullshit. I'm reposting what is already is. Okay? And that is my intent. I've let it be known from the start. See Garcia versus Montgomery County, Maryland. Citing Garrett versus Began, 2014. American Civil Liberties Union of Illinois versus Alvarez, 7th Circuit, 2012. State law prohibiting recording of police officers performing their duties in public violated the First Amendment. This is already known. And like I said, equality of the law among the states. What's good in one state is good in all states. Why? Because that state went to the Constitution. It has to. In making its case law, it has to go to the Constitution, confirming that the state constitution confers with the federal Constitution, and there if that state law violates either the state or the federal Constitution, it is in fact a violation of the federal Constitution. And I'm telling you that if it is a violation of the federal Constitution, it is a violation of the Constitution of the Universal Postal Union, which is where the Constitution of the United States gets its powers. Then it goes on with another case, Fordyce versus, these are all case laws that you guys need to look up and read. Fordyce versus City of Seattle, 9th Circuit, 1995, Smith versus City of Cumming, 2000. The reasoning, I always talk about reason and logic. The reasoning behind these decisions is that gathering of information about government officials in a form that can be rapidly disseminated serves a cardinal First Amendment interest, not a constitutional penal code, but an interest, the principle of it, in protecting and promoting the free discussion of governmental affairs. Again, we see it going back to the preamble of the Treaty of Berne, where it talks about communication, which is the discussion. And that First Amendment interest is not just in the discussion of governmental affairs, like I said. When I do my First Amendment audits, I may go out to do a First Amendment audit and find out there's no one that needs to be approached on the First Amendment, and therefore the audit is a audit of natural occurrences. And I hope to get some discussions, not necessarily just with public officials, but other private people. And therefore, even though it may start out as a First Amendment audit, it remains a First Amendment audit, but it doesn't involve public officials. So therefore, it contains education with other private individuals about First Amendment and the gathering and dissemination of information, which even if I'm approached by private peoples. I have to let them know that I have the intent of gathering and disseminating information. Please keep it peaceful. Okay? It's called communicating right from the start. You don't start recording without communicating and letting them know your intent and say that I'm just asserting my First Amendment audit, when in fact you have a deeper interest in gathering information as a way to disseminate the errors that our public officials make in public forums. I'm not here to charge you. I'm here to point out that you're making mistakes, or I'm here to point out that you're complying, and I appreciate you. I appreciate a public official that comprehends the constitutions and how they work. Because I don't care how you write them, the intent is no harm in all cases. That's why you have a Treaty of Berne that says you can communicate as long as your intent is not to harm, and then it's supported by a law of nations for enforcement in case harm does come about. That's why they're sister documents and not patronymical documents. That is the concept of having sister entities. Again, we are not to pay honor to an earthly father. So we pay honor to sister documents. Okay? This is where many, even scholars in my opinion, fail to recognize where the cardinal source comes from. Inherently, it comes from the private originator. Not from the scriptures, not from Hinduism, not from Muslim, not from Buddhism, Hinduism, Christianity, Protestants, baptism. It doesn't come from any of that. It comes from yourself. You have the authority to express anything you want. There's no law that says you can't. And you can do it any way you want. Again, no law that says you can't. As long as you don't harm anybody in doing so. Private originator of any material and can be expressed in any medium so long as it is not harmful. Expressed, it is noted in the preamble of the Treaty of Berne. Communication. You can communicate it in any way. It does not say communicate in writing only, or communicate in telecommunications only, or communicate in internet email communications only. It says communication. Therefore, not limiting it in any manner, meaning any communication. This is what we're talking about with the remedy of things that are not denoted as a right. It doesn't say that you can't do it, so you can do it. Not all courts have agreed, though. A recent decision out of Pennsylvania, and this is why I urge people to stay up with case laws and at least get involved in some way in the laws that are actually forming the way we think today. They're confining by defining and refining what was already previously written according to incidents that happened, and they're based on opinions of those incidents and the intents that were reasonably and logically adjudicated. Okay? Pennsylvania has ignited a controversy where the court concluded that 2 citizens did not enjoy a First Amendment right to photograph police, absent any criticism or challenge to the specific police conduct. Yes. So, like I said earlier, if I'm out doing a audit, and I hope these First Amendment auditors will catch on to this. Quit saying that you're expressing your First Amendment right. That's confining you to that Constitution and that First Amendment. Expand it above and beyond that, and let them know that you are here to challenge their authority. You are here to challenge their authority right from the start. Do not let it be disseminated in any other way, that you are not subject to the Constitution yourself, and that they are, and that you are here to challenge that authority. Why would you challenge that authority? Because like I have expressed, that Constitution gets its authority from the Constitution of the Universal Postal Union, which indentures the law of nations, and the Treaty of Berne, which talks about communications. And as far as I know, he knew me before he formed me in the belly. He sanctified me and ordained me a prophet unto the nations before I was cast from the womb. That was the original communication, and that is what I pray to, our Father which art in heaven, because he communicated that to me in my heart, not in a written code. And that's what I am challenging. According to that judge, because the individual filming law enforcement did not advance a particular expressive purpose other than their right to record. In other words, they didn't explain what they were going to do with it after they recorded it. They didn't express any other intent except to record. Okay?
I gotta go check on Brie. She's not feeling good.
And in order to express your right to record, you cannot leave it to further clarifications. Because if you have a right to record, but then you have a further intent to use it against them in a harmful way, you have to let them know that the only way it can be used against them in a harmful way is if they harm themselves. Because your intent is not to harm them. Your intent is to expose how they are being unlawful, how they are breaching the peace, how they are being seditious in their communications to the public by parking in handicapped places when they are in fact not handicapped, and there are laws saying you are not supposed to do that, and they are the ones upholding those laws, and therefore in violating that law, they are communicating to the people that they do not have to follow the law, and I challenge that. That's why I'm recording. I'm not recording because I have a First Amendment right, because that ain't my right. That's what somebody else wrote down. Me? My intent, regardless of any right, my intent is to challenge authority in all cases. That's why I record. They were not exercising protected speech under the First Amendment. If you don't express that, you are not exercising protected speech. You are only trying to exercise a portion of it, and by not expressing it fully, you are not actually exercising it and don't know what the fuck you're talking about. Using that court's own logic, though, and this is what I present to all First Amendment auditors and why I'm doing this video today. There's one comment. Using that court's own logic, had those two citizens claimed that they were using the recordings to challenge police actions, their conduct would have qualified as protected speech under the First Amendment. That's your remedy, folks. You provide remedy by notice before the interactions or at the point of interactions. Thus, in this case, when these two ladies called the police because their neighbor was harassing them, in this case, the two women who called on a neighbor harassing them could have made note to the dispatcher or the officer arriving on scene that they have a specific intent in recording the interactions to being their challenge to the law, not the officers, to the authority, which is the law. Okay? These officers have no authority. And they will tell you, well, according to this, that tells you that's where they think they're getting their authority. Okay? 100% of the time, they will refer to a law. Not one of them will ever say, I have authority over you. They will always refer to a law. In other words, it places the concept of freedom of speech outside any particular event or incident. Okay? I'm not challenging the officer. I'm recording the officer's conduct so I can challenge any authority that might say that something here is not the way I perceive it, when in fact the video shows you exactly what I perceive. Okay? Does it really matter whether or not recording law enforcement is guaranteed and protected by the First Amendment? No. In reality, in all reality, all cases, every incident, I will keep professing this. This debate only comes into play in situations where people want to pursue a civil or criminal suit against law enforcement for prohibiting or interfering with attempts to record. That's why I say, you First Amendment auditors, you really need to understand the concept goes beyond recording to then editing and posing it in a specific way according to your intent. Like I said, if I have no intent of challenging the law and my intent is purely to make a satirical comedy, I can go ahead and record the police and edit it my own way and make it a satirical comedy and not, in fact, challenge their law. So I have to state my intent. So my intent is to challenge the authority. And in challenging the authority, if I want to make a recording of it and then disseminate it later, I can do it for court purposes, or I can do it for my own entertainment and educational purposes for others to view online in satire. That's up to me, no one else. And that is not written in any law. Nowhere does it say you have to protect your right. Only under Saturday Night Live contract terms and conditions to put it out satirically. I can be quite serious about it and make a valid claim in the public record. I do not have to place a claim in their private court records. I can place a claim in the public venue, and I have done so. I have done so. I let them know they were violating 15 U.S.C. 1 and 15 U.S.C. 3, and that hiring an attorney would prove them incompetent and automatically be a win for the case. Automatically. Because if you come to court with an attorney trying to disprove this in a public trust, a public notice, you've already proven that you were incompetent to begin with and violated this, because then you turned around and hired an attorney after I already gave you private notice. I gave them private notice. Then when they wanted to refuse that notice, I gave them a public notice following Matthew 18, verses 15 through 18. 15 through 20. We didn't make it through 20. We got to 16. And they resolved the problem through back office executive management. Now my next one's going to be to Zoom here in another couple days. In these lawsuits, law enforcement is allowed. They are allowed to advance the defense of qualified immunity, which gives them shelter from lawsuits for violating citizens' rights that may not be clearly established. If you think that the First Amendment right clearly establishes your right, it does not. You have to establish it by knowing all elements of it. That's the importance of that First Amendment, knowing all elements of it. not just knowing that you have the right to record. That's bullshit. So again, I urge you First Amendment auditors to wake up and realize you have a higher duty. And what you're doing now is just the same thing as these police. You are failing that duty by not knowing the higher purpose. And in so doing, you are operating just like the police, gathering and disseminating information falsely without knowing the proper intent or expressing the proper intent. Man, I got to get rid of that guy. This Sharif Judah guy, I got to get rid of him. He's a babbling idiot. Just so everybody knows, I just had a conversation with him on a brother's. He has got an ego claiming he is both a debt collector and a creditor. I give all credence to our Father which art in heaven. Hallowed be thy name. And this guy's using all kinds of names, claiming to be a creditor and a debtor. What a dumbass. I'll put him out there on Front Street right now. Anyway, back to my expose here. My journalese. Rights that may not be clearly established, and this is right from them at the time the violation occurs. See, you don't have a pre-existing right to record. It's false. You don't have a right to disseminate it later on. That's false. You have to clearly establish at the time what is happening, not what might have happened in the past according to your opinion, or what might happen according to your opinion of the incidents now. You have to be able to clearly establish in the now time. This is for the most part aired, in that most of these cases also implicate an illegal search and seizure by law enforcement, because force would have to be used to prevent the recording. So in every case that they try to profess that there's immunity, that they have qualified immunity, they've already, by that profession alone, they've professed that they have, by force, taken something or prevented something, which is not allowed for in law. So by being allowed to use immunity in that fashion and using it in that fashion, they themselves profess that they have in fact violated the law. Okay? Comprehend this, folks. This is why they don't get away with shit with me. I let them know you've already violated the law. You can't proceed any further. You have violated my intent, which had no harmful intent, and you did so by harming me. That is the violation. Nowhere else can you go to escape that violation. While it is certainly an intriguing legal debate, practically speaking, other well-established legal causes of action already exist to remedy the violation without need to continuously fling shit at the wall, hoping it will stick, or following someone's process that has not been established and noted well enough to actually prove useful in petition. And this is what I'm going to bring Chris Hauser in. And you've heard me talk about Chris Hauser, and Chris Hauser's a wonderful guy. I love him. But again, I mentioned to him in his own case, they're pressing forgery charges. Well, that forgery charge has to have an intent. And because he did not state this intent of not causing any harm, that is what they are going on. He did not establish the intent of his process, regardless. He did not establish the intent of challenging the fact that he could not do it by doing no harm. That he, in fact, had the ability to make assignments to the right people to convey the exact same concept of having access to the minor account as the benefactor, and not some outside third-party intervener trying to violate the trust. Okay? If you're dealing with that fictional trust, it is a process. But you have to make clear that in that process, in the intent of initiating the process, your intent at the end. The effect. The effect. Leaving the debate over the genesis of the constitutional right to record law enforcement in public to the legal scholars prevents, in reality, any diverse remedial actions. Everybody, like these First Amendment auditors, going to that First Amendment and not expanding upon it by learning more about it themselves and just sticking, well, I got the right to record, is the same thing as teaching a man how to fish, but not teaching him how to teach others. So then he goes on and he learns how to fish and he feeds himself through that own ego all of his life, but never teaches anybody else how to fish. You're stuck in the same cognitive dissonance that the police are as a First Amendment auditor. Okay? An approach, in my opinion, that better captures the true spirit of individual freedoms is one that, instead of asking, where does my right to do something come from, ask, what says I can't? This is what I've been doing all this time. What says I can't? Well, this says you can't. Well, according to this, it says I have to do this, this, and this, and I haven't done that. So this doesn't qualify me as having to do that. Well, this says it. No, this says this too. And according to this, it disqualifies me here. This is the remedy I spoke of earlier, as it is the point of origination of thought and creativity. See, when everybody subjects themselves to that public education and delineates themselves to that same language, doing the same thing that everybody else is doing, well, if somebody jumped off a bridge, would you do it? No. Well, then why are you using the excuse that, well, everybody else does it? That's the fallacy of it. Right there. If everybody else is doing it, does that mean you should do it too? Well, by reason of logic, it says it does. So if everybody else is jumping off a bridge and you get to that bridge, do you have a right to say, well, wait a minute, I don't want to do it? Where is it that says that everybody is doing it, so you must do it too? There isn't. This is the fallacy of all of their systems. I learned long ago that if one believes there is only one solution, it is because somewhere creativity was taken out of the equation. This is where I want to talk about this young man. I think he's 8 years old now, but I met him when he was 6 years old. We were having an adult conversation, myself and another young man. And this little fella, at 6 years of age at the time, interrupted the conversation. He looked me dead in the eyes. He said, most people are dead their entire lives. Most people are dead their entire lives. And this is because they go into a public education system and they're indoctrinated and delineated into remembering certain things. Now, this is the same kid that when he was in preschool, and they gave him this table with these little cutout shapes to shove through these little cutout holes in the tabletop to put them inside. He took all of the elements, and rather than taking the little hammer and matching them up shape to shape and pounding them through the tabletop into the container underneath, he lifted the tabletop up and put them all in the basket at once. The teacher looked at him and said, no, that's wrong. That's the problem with this system, folks. That little kid at 6 years old, or before he was 6, this was when he was in preschool. So when he was a very young kid, he was finding his own solutions. He was using creativity. He was using the diversity of his own thoughts. And the school system is tearing that apart right from the start. That's how it's designed. That's what it does. That's what its intent is. And that is the effect. So, turning the question on its head and asking what prevents one from recording the incident more appropriately embodies the issue. Now, once you ask that question, I should have put this in there. If it doesn't prevent you from recording it, does it prevent you from changing it around to fit something a little bit better according to your intents of use? Now, in that intent of use, is it going to remain private so you can giggle at it when you read it yourself? Or do you intend to republish it and put it out there and disseminate it for others to view to get their opinions? See, this is how the court system works. They're getting opinions. They're getting the public opinion. Oh my God, somebody was arrested for meth, and they caught him sitting at a stop sign because somebody's camera was on at the local police department. And this is a true story, folks, right here in Waterloo. Somebody got caught with a meth lab in their trunk because the local police department's camera sat there and watched this guy sit through several lights. So one of the officers conveniently didn't even have to go through the expense of hopping in a car and going to where he was at because it was right across the street from the police station. And they went out and found the guy dead asleep in his car, sitting through several red lights, green lights, as they changed back and forth. He just sat there, car running. And so when they finally searched, they found a meth lab in his trunk. Now they put a nice little story publicly in the paper. And that guy has a right to privacy. If he'd kept it in private. But since he was in public, oh goodness, they get to write it any way they want. You see how that works, folks? They get to write it any way they want. So they made it look like this guy was a really bad guy when he's just a simple guy like me and you, and he had a problem, and it got found in public. That's all it is. The guy actually didn't do anything wrong. He actually didn't do anything against the law. It's just a matter of where he was at and who could record it and what their intent is. And their intent is always to make you look bad. Always. Always. They don't pull you over and give you a commendation for being a good driver. Hey, I noticed I've been following you for the last 15 fucking miles. Dude, you are awesome. Man, you didn't have one infraction, dude. I had to stop you and give you a big hug. Step on out, please. They don't do that, do they? Think about it. So let's go on. It is fundamental principle that if a law does not prohibit a certain conduct, we as people are free to engage in it to our heart's content. In most states, there is no prohibition from filming or documenting anything taking place in public view, so long as the individual being filmed does not have a reasonable expectation of privacy. So that guy sitting at the light, his reasonable expectation of privacy is halted when the guy sitting behind him at that green light that changed green and he didn't move. He had to change his path. He had to alter his path of travel. So now they have an open reason to open this guy's door, say, hey, you interfered with traffic. Sorry, don't know what to tell you. And you did so in public. You did it on our cameras. We caught it. We're going to disseminate it. And we're going to disseminate it this way, whether you like it or not. Stand up and fight it. We dare you. And that's exactly what they do. You guys really have to quit doing this stupid shit. And granted, that's an exceptional case, but it is exceptionally stupid. In most states, there is no prohibition from anybody documenting, filming anything taking place in public view, so long as the individual being filmed does not have a reasonable expectation of privacy at the time of being photographed. At the time. There's that at the time thing. Okay, this is those traffic citations that are given out by the video cameras. Okay, you get the traffic citation, but there is no one manning it at the time. Somebody caught it 8 hours later, videoed it, and said, okay, here's a guy that ran a red light. Because the machine itself doesn't recognize that somebody ran a red light. It's somebody that views it later on and says, oh, here's one that ran a red light. We got to send him a citation. Now, he wasn't there at the time. Okay? He is not, in fact, a first-hand witness. He is using a recorded event with no intent written anywhere. Nowhere is the intent of that written. Nowhere. None of those. The only intent that is ever stated anywhere is a penal fine or penalty, imprisonment. That's their intent. Okay? There's no better example of this phenomenon than the viral episode of spontaneous public entertainment that on top of the 18-wheeler in the middle of Houston's Highway 290 during a traffic jam. I can't remember what year. It wasn't too long ago. But I remember a video, and I'll see if I can find it and post it. Look it up. You should just be able to put Houston Highway 290 traffic jam, and it should come up, and you'll see people party on top of a semi. Don't know what I'm talking about? Search it at your own risk. There are certain restrictions on how a person may use the recording after it is obtained, and I may discuss that at some other time. As we've already discussed, you have to have an intent of what you're going to use it for after you obtain it. Okay, so we'll discuss that later on. Like I said, I got into some details earlier about whether you use it against them or maybe a satirical skit or whatever. We might do that some other time, and I may discuss it. For this succession, we will remain on the intent of the challenge of another in now time as it is recorded. That's what we're dealing with right now. So when those two women in that Pennsylvania court case recently called the police, they could have told them, hey, we're going to record this just so you know, so that if anybody does anything wrong from this time on, we have substantiating proof that what we're saying is true as opposed to what the neighbor is saying. Okay? And that shows that you're challenging a record and not the police. So when the police get here, we're not challenging the police. We're recording so we can challenge the neighbor's issue of a false claim. So please be aware, we're going to be we're going to be recording you. You are going to be recorded, but we have our own private purpose, and it's not because we want to hold you accountable or the neighbor. We want to hold what the neighbor is putting into the record as a challenge. Okay, we're going to contest the record. We're not here with a right to bear arms and shoot somebody if we find out they did something wrong. Because after we prove that they did something wrong, now we have a recourse. No, that's not what we're here for. We're here to correct the record. We're going to put an end to this stupid shit. Okay? And by doing so, we educate people. We don't shoot them down. We don't hunt them down. We don't imprison them. We educate them. That is the true remedy, education. If a fellow stranded motorist can legally film traffic jam entertainment, if a tourist can walk around freely filming their experience of a new town, if a citizen can take a selfie with an Irish guard outside of Buckingham Palace, why can't that same citizen snap a picture of NYPD's finest, scarfing down a delicious Bavarian cream donut, or better yet, roughly arresting another citizen at a public protest? The rational answer is they can. You can. You can do it from 300 feet away with a nice telescopic lens, or you can do it with your own cheap phone from 8 feet away. 8 feet. Okay? Nothing says you cannot do so. Nothing says you cannot, so you can. In a day and age where security cameras are on the exterior of most buildings, intersections are equipped with traffic cameras, and Google has brought a photographic view to the entire world into our own offices and living room. A person would be hard-pressed to claim an expectation of privacy in normal public space. Can't be had. It cannot be had. This is why they express this. If you're in public, you have no expectation of privacy. None. This goes to public servants and private people. Once you go out into public, you have no expectation of privacy. You have to create it. That onus is on you. First Amendment auditors telling these other people that the onus on them keeping their records private is on them. Well, the onus is on you to establish the fact that you are creating a private record which you intend to disseminate publicly if it need to be. Okay? Without doing that, you're failing your First Amendment audit, guys. You have that same onus. You have that same responsibility. So quit doing these First Amendment audits without knowing that. You have that same responsibility. And if you're going to be people, if you're watching these First Amendment audits and trying to learn this so you can go out and do the same thing, remember, 98% of these First Amendment audits are being done wrong. Just like 98% of the tax, income tax being paid is being paid voluntarily. That's wrong. You shouldn't be paying that tax voluntarily, because that's what creates 98% of the record, saying that 98% of people have to do this because they've been doing it all this time. If 100 people are doing it, should you do it too? If 100 people jump off a bridge, should you do it too? That's false logic, people. Certainly what goes on in broad daylight on a public street is fair game for any and all to witness and document accordingly. This is why one need to let them know at the time of the recording that the recording itself is to dismiss any future or current challenges to what is true. It is not basing your opinion. It is not so you can disseminate later for your opinion, but so that you can record at the time what is true at the time, and then maybe later disseminate it in your own private opinion. The issues can become a little complex when we start talking about more than snapping photographs or video, and this is why I said I'll discuss this maybe at a later time. Because like I said, you got to have an intent of your effect. If your effect is commercial, to expand it in a commercial venue by doing a satirical YouTube, and that's where you get your YouTube compensation, then you can do that. Or maybe you intend to write a book and have a compilation of many of these that you're recording so you can review them later on and write down specific quotes for a book. So you don't necessarily have to put out a video because you video recorded it. You can then translate it to a book. So again, I'll do a video on that later on. But for right now, let's stick to the current now time acts and the intent of what we want to affect. And that is the challenge of the record. Most video recordings also record audio. And again, this is a situation where I'll get into maybe later. Your intent, your right to record is both visually and audio. So no matter what they want to talk about their wiretapping laws, that has no effect on this. Again, that maintains to somebody establishing the onus of privacy. Whereas if everything's in a public venue and that privacy hasn't been established, then you cannot be possibly violating the wiretapping laws. Okay? Additionally, there may certainly be situations where a citizen may want to create an audio recording without law enforcement or government officials knowing. The reason being is that a citizen is more likely to capture the true character of a government official when the official is not aware of where they are being recorded, compared to when they are staring down the lens of a video camera. And again, this is why I mentioned you can get a camera and have a telescopic lens and record them from 300 feet away in their natural capacity because they don't know you're recording them. Okay? Or you can do so at 8 feet, right there in front of them. And again, those laws that you look up, you'll find the one that says 8 feet. That's their limit, 8 feet. And when they try to expand upon 8 feet, sorry, you're violating the case law already established. In a vast majority of states, including Iowa, this is a non-issue. Citizens are free to create audio recordings of things that take place in public. This is, again, your right to record. There's no distinction. For the sake of brevity, we will not delve into the finer points of one-party versus two-party recording states as it pertains to conversations and communications that take place outside of the public realm, where one of the parties may be considered to have an expectation of privacy in their conversation. This is where you go up to maybe go up to the clerk of court's window and somebody's in the back corner and they're having a private conversation. You can record your conversation with the clerk, and if somebody's private conversation in the background is recorded and they're talking about kidnapping somebody, hey, that onus is on them. They spoke loud enough for it to be recorded. If they really wanted to have a private conversation, they needed to go into a private room, soundproof, hopefully, and have that private conversation where nobody else is around. Otherwise, they cannot say I was wiretapping them, period. No law specifically, it suffices to say that in the vast majority of states, no law specifically prohibits citizens from recording whatever is audible to the general public. Citizens in those states are free to record away simply based upon the fact that no law says they cannot. There's no law that says you cannot record either. There are laws that say that you have a certain distance you have to be so that you're not infringing upon their conduct. But that's it. And that's 8 feet. Any state law prohibiting anything constitutionally mandated is by operation null and void and can be done with impunity. This is why I say if you're traveling down the road and they want to pull you over for driving, I'm sorry, you get to practice that with impunity because that state statute does not apply to you. You have not implemented it unless you have a driver's license. Unless you have that driver's license and have a record of it in the state. And that was the problem with mine when I put those private placards on. I had a license so I could drive when I needed to drive, but I put the private placards on and then handed him a driver's license. Okay? You give them that excuse, and that's what they're going to use as their intent. I offered up an instrument that showed them proof that I already knew their intent. And that I shouldn't have given them that instrument. I should have provided the private credentials that are allowed. Hey, you need to call my attorney. Or my counsel, as I should say, counsel. Certainly with litigation popping up all over the country on these issues, we should expect the United States Supreme Court and various state Supreme Courts to weigh in definitively on this issue soon. We're not going to keep putting up with it. And like I said, these First Amendment auditors are bringing this issue to light. But that the courts are just going to keep recording it in their opinion until somebody brings up this very issue is that, hey, these recordings have to have a stated intent. And in that stated intent, the final outcome is the effect. And that is what we are weighing the issue on. We have the way of the issue to be able to publish what we have provided or the way we opinionate it in our own ability in any venue. Okay? I have the right to post my opinion in their public venue by giving them public notice. Hey, I wish to print this in your in your private records. Now they can deny it. But in posting it in the public venue and exposing that private record, they'll get rid of that record or they'll come to agreement with me, say, hey, can you remove that from the public record? We'll remove our damaging statements from our record if you remove your damaging statements from your public record. Okay? That's your remedy. Your remedy is the intent. The expectation of being able to publish your property, publish your opinion of your interactions peacefully to the rest of the world. Just like they do when they put it in a public newspaper. Oh, we caught this guy. He had a meth lab in his trunk and everything. And they put a bad light on you. You have the right to put a bad light on them in the public venue. Which, by the way, I hope to have my ability to post public notices here up one of these days soon. That way I can publicly notice people for you as a third party. Peaceful intent, not involved. And my intent is expressly peaceful. I have no weapons. I profess my peace. And it is established in the international forum as a peaceful unit. Until then, if nothing says you cannot record, you can record. Nothing says you cannot drive, so you can drive. But that does not mean you should drive. There's nothing that says you can't travel, so you can travel. The problem is you have to be able to express how you're traveling and not driving. You have to be able to express how you're going to publish and not just record. Okay? You have to show your intent. If a law says you cannot record events taking place in public, it violates the First Amendment to the United States Constitution. Without fail. Without fail. To quote the First Circuit Court of Appeals, ensuring the public's right to gather information about their officials not only aids in the uncovering of abuses, but also may have the salutary effect on the functioning of government more generally, without saying that you have the right to publish it. Have a salutary effect. Rather than a statutory effect, it has a salutary effect on the functioning of government more generally. Okay, this is a Glick versus Cuniff. This is one of the most profound cases you should know about. Glick versus Cuniff. Read it. Thus, not only is your right to record law enforcement in public, it is your duty, as in your neighbor's neighbor, to promote and assist in the dissemination of information that fuels the free government or free discussion of governmental affairs. Bottom line, keep those cameras and recorders rolling. Keep them recording and rolling, folks. But in the meantime, learn how to format that recording into a publication with intent for an effect. Without that, your First Amendment audit is going to fail for effect. You might think that you did a good job and you got away, you weren't arrested, and you taught that post office man that you're going to come back, or anybody has the right. But in the meantime, nothing educational-wise had any effect. The next guy that comes along, they're going to force him to establish that same thing. And if he too does the same thing and doesn't establish his intent to effectively publish their unlawful activities and make a valid claim to the right people, then publishing it still does no good. Think about this, people. Everything I do has an intent to pass on knowledge. That's my intent. And education. I have no intent to harm anybody. I have no intent for private gain for my own self through commercial practices. I have no intent to be politicalized. I have no intent to be religioned. I am Legion. I am with him at all times. I don't need any of this extra shit that they put in their written statements, because those aren't my intents, because they have no foundational intent other than the penal code, and that is for imprisonment and commercial fines, penalties, fees, taxes, surcharges, and whatever. It's not for me. It's not for you either, I don't think. But again, that's up to you. That's for your intents and purposes, for your effects. If you want to gain all those worldly material gain and be all gold bling and everything, go ahead. Act in that person. It's up to you. If you want to record these people and show how they're taking your bling, I suggest you learn what the intent and purpose of that bling is, so you can come out of her and put these people to task to doing their job as they're supposed to, and see how that wealth will spread. That's the true wealth, the knowledge. In the meantime, I've made this long enough. Like I said, I'll put those, the Lord's Prayer, Treaty of Berne, Preamble, Constitution of UPU, Article 1, First Prayer of Congress, Preamble of the U.S. Constitution, U.S. Constitution, Article 1, Section 8, Clause 8. Think about those. And remember, you have to learn your own intents and purposes before you go asserting that First Amendment audit. Because if you don't, and you're going by that First Amendment audit's intent, then you're going by that constitutional intent. And that's a commercial intent. You're telling them that you have the right to record and you intend to disseminate it commercially to harm somebody else. Or you don't tell them that, and they have this thing, well, is he going to post it to harm us? Well, that would be detrimental. We better arrest him. And then you stand there and try to fight, well, I recorded, I have a right to record. Yeah, you have a right to record, but you don't have the right to record it and then harm us without telling us that you intend to harm us. However, like I said, as a remedy and a different approach, coming at them and letting them know that you are going to record them for this specific intent. And that is not to come after them and harm them, but to challenge the lawful authority written in the record. Then all you're doing is challenging the written word. Okay? That way, if they do something wrong, all you have to do is point out, see, according to the word here, it says you were supposed to do this, but you didn't. So here I'm gonna educate you. Now, if your penal system and the people that your superiors that you're subject to decide to penalize you and put you in prison and fine you according to their statutes and codes, then they can do that. But I can't. I can't do that. I can't bring harm to you. I can't penalize you. That's their code. I'm not subject to it. Therefore, I can't use it against you. I can quote it and show you where it's at. That shows that you're doing wrong under fair use. But other than that, my intents and purposes here in recording you, just like you're recording me, is to place a record and have an effect. My effect is for education, for all purposes, to clear up the record. Because that's what's wrong. We need to correct the record. When we learn how to correct that record, then the people operating on that record will automatically be corrected. So again, I'm not... 6 years ago I was belligerent and I did hold it against him. I told him I was going to sue him. I was going to, $47 million, $1 million for every day, blah, blah, blah. It's all insanity. It's all insanity, folks. So I hope you can come out of her and learn that the true benefit is education and that it extends from in beginning was the Word was with God, and the Word was God, and that Word of God is love, and that's where our benefit comes from, is loving another to be able to teach them, no matter how bad they've acted. I don't care if one of the officers that I might approach someday has a rap sheet on his record that he killed somebody. I don't care. That's not up to me. I'm not here to make a determination on that. I'm here to educate, and that's it. See, Jesus didn't go out and teach to the bankers at their temples. He didn't go to the stores and say, hey, here's the Word of God. He went to the temple. Okay, and that's why he kicked him out of the temple. For those with eyes to see and ears to hear, that's who we preach the gospel unto. And so if the bankers want to come to the temple, they come to hear the word and not to push their wares, because that's not what the temple's for. That's not what this temple's for. It's not for somebody else to push their wares. So again, I hope everybody paid attention today. Remember, if it weren't for you guys, I wouldn't be doing this. God bless. I love you all. I'll get this posted in my YouTube channel, and like I said, I'll get those comments posted so you can remember those and look those up. And remember, it's already in your heart. Quit with all the other bullshit and get back to the principle, which is not the written legislative word, but the intent behind that written legislative word. So again, God bless. Have a good day, and I'll see you next time.